Welcome back to the Constitutional Clarion. You often hear people advocating for truth in political advertising laws these days at both the federal and state levels. Apparently, it's really easy. You just do what the South Australians do and suddenly elections will be truthful and fair and everyone will behave well. But as you've probably guessed, it's just not that easy. And there is a very real risk that you could end up making things worse. How? Well, let me explain. When people complain about deceitful political campaigns, they commonly mention the Medi-scare claims at the 2016 election that the coalition would privatise Medicare if elected, and the claims at the 2019 election that Labor would introduce a death tax. Others point to promises made in election campaigns that are later not kept. For example, Tony Abbott's no cuts to education, no cuts to health claim, and Julia Gillard's no carbon tax under the government I lead claim. It's argued that if we had a truth in political advertising law, this could not happen. But in reality, that's just not the case. One needs to distinguish between verifiable statements of fact on the one hand and assertions which cannot be proved one way or the other, promises, opinions, and predictions. It's only the first category, verifiable statements of fact, which can be addressed by a truth in political advertising law. Most election campaigns, however, tend to focus on unprovable assertions, promises, opinions, and predictions. Campaigns, of course, are primarily about promises to act in a particular way in the future. When a promise is not later fulfilled, this does not necessarily mean that the person who made it was lying at the time. Sometimes it's just not possible to fulfill a promise. For example, there may be legal or constitutional reasons why it can't be done. Or circumstances may have changed so that it would be irresponsible to give effect to the promise. So, for example, there could be a war, a pandemic, a natural disaster, a financial crisis, or any number of other changed circumstances. Breaching a promise in those circumstances is the rational and responsible thing to do. The truth of a promise cannot be genuinely assessed at the time the promise is made because we can't know whether or not the promise will be kept. But nor can it be judged later by reference to whether or not it has been fulfilled because, of course, the circumstances may have changed. For example, in the case of Featherston and Tully No. 2 from 2002, the Supreme Court of South Australia dealt with a challenge to the election of an independent candidate who had stated in electoral advertisements that he would not support the formation of a Labor government, but in fact later did. The court found that the petitioner, that's the person who's bringing the complaint, the petitioner had failed to establish that at any time before the election, the candidate had intended to support the Labor Party to form a government. He only decided after the election to support the Labor Party in forming a government. His pre-election statements were therefore, according to the court, not inaccurate or misleading at the time they were made. During campaigns, many politicians and parties will offer opinions about their opponents. They may say that Party A is the better economic manager or that Party B is untrustworthy. Opinions are simply the views of those who offer them, and they're not matters that can be verified as true or false. In the case of Hannah and Sibbons from 2010, the South Australian Supreme Court found that advertisements stating that a candidate was soft on crime, hoons and drugs was an assertion of opinion and that it therefore did not amount to misleading advertising for the purposes of the South Australian law. The other key component of election campaigns, of course, is predictions. Claims may be made that Party C will or will not stop the boats, or that interest rates will be higher under Party D. As they are predictions, no one can know whether they will come true, particularly as circumstances affecting future outcomes may change. They are inherently undeterminable as matters of truth when they are made. The type of truth in political advertising law that is commonly proposed in Australia is one that's similar to the South Australian law, that is, Section 113(2) of the Electoral Act 1985. It says this: a person who authorises, causes or permits the publication of an electoral advertisement is guilty of an offence if the advertisement contains a statement purporting to be a statement of fact that is inaccurate and misleading to a material extent. The section only deals with purported statements of fact, and that statement must be one that can be determined to be inaccurate and misleading to a material extent to trigger the application of the offence. The penalties are also very low, a fine of $5,000 for a natural person and $25,000 for a body corporate. Section 113(4) also allows the Electoral Commissioner, if satisfied that an electoral advertisement contains a statement purporting to be a statement of fact that is inaccurate and misleading to a material extent, to request the advertiser to withdraw the advertisement or publish a retraction to it. The advertiser's response is then taken into account in the assessment of the penalty to which the advertiser is liable. So how would such a law address claims by a political opponent that if elected, Party X will privatise Medicare or introduce death duties? First, it's unlikely that such claims would be made in formal advertisements. They would more likely be made in social media posts or on texts to your mobile phone or robocalls or just oral statements made to the media so that they wouldn't be caught by such a law. Second, it's a prediction or an opinion here rather than a statement of facts, so on that basis it wouldn't be caught. Third, if it were regarded as purporting to be a statement of fact, how would one go about investigating its veracity and determining whether it was inaccurate or misleading? Would relevant politicians have to produce all their emails, texts and communications on WhatsApp and Telegram to show that they had no secret plans to privatise Medicare or introduce death duties? You can imagine the political minefield that this would produce. The mere denial of a secret plan does not itself establish the truth or falsity of a claim that there is a secret plan, because secret plans by their very nature are kept secret. Fourth, the provision is very easily avoided. If a political party wants to make inaccurate or misleading claims about its opponent's policies or likely future conduct, it just frames them so that they're not statements of fact. It could form them as predictions, opinions, even questions. For example, one advertisement during the Voice referendum campaign just asked the following questions. Will the Voice, 1, have a veto over Australian law? 2, have special rights based on race? 3, be a front for politicians? 4, take Australia from its citizens? Asking questions can be sufficient to raise concerns without any need to make statements of purported fact. Alternatively, a political party can very effectively spread inaccurate and misleading claims outside of political advertising through media reporting of statements and speeches or press conferences or doorstops, or just simply through social media. In short, professionally organised political parties would be unlikely to be caught by such a law, unless they deliberately wanted to be caught, to benefit from the free publicity that this would cause. And this is another real problem. One person, once prosecuted in South Australia, claimed that the small fine imposed for their inaccurate advertisement was great value for money, given the free publicity for the claim that it generated in the media. So would such a law achieve what the people advocating for it actually want? The answer, I'm afraid, is no. It would not stop scare campaigns about death duties or the privatisation of Medicare or whatever happens to be the issue du jour. The next problem is who determines the truth of an assertion or whether it's inaccurate or misleading. Neither electoral commissions nor the courts would wish to be involved in such sensitive political assessments because of the potential damage to their reputations and trust in them. Even when determining strictly matters of fact, facts can be contested and people can rely on different evidence to reach different conclusions. Would the Electoral Commission, for example, have the capacity to rule on the truth of statements made about the cost of developing nuclear power in Australia or Australia's future defence needs? Any finding would also lead to significant political consequences. For example, if a complaint were made to the Electoral Commission about a claim by Party Y that Party X was going to introduce death duties if elected, and the Electoral Commission took no action or dismissed the complaint because it could not establish the truth or falsity of such an assertion, then Party Y would no doubt publicly parade this finding as a vindication of its assertion that Party X was going to introduce death duties. You can see the problem about how such laws could be manipulated and misused. Electoral commissions, which rely on bipartisan support for their effective operation, do not want to be perceived as biased by reference to decisions that they make about the veracity of contentious political claims, particularly during a fraught electoral campaign. Electoral commissions don't have the expert staff to make such assessments, they don't have the inbuilt processes to achieve procedural fairness, and at election time, they need to focus all their attention on delivering free, fair and functional elections, so they really just don't have the time and capacity to deal with these issues. While the courts are better placed to make such assessments and are obliged from time to time to make judgments on politically contentious matters, they too seek to avoid determining internal political matters where at all possible. To do so, they rely on the principle of the separation of powers, the non-justiciability of certain types of political questions, and the ability to read down offences to avoid these problems. For example, in the case of Evans and Crichton-Browne, the election of 3 senators was separately challenged based on misleading electoral advertisements. They included statements that Democrat senators had in the last parliament voted with Labor 8 times out of 10, and a vote for Democrats could be a vote for Labor, as well as some ads that claimed that Labor plans to snoop on your money and introduce a wealth tax. The High Court was so reluctant to rule on such matters that it read down a statutory provision which made it an electoral offence to publish any electoral advertisement, quote, containing any untrue or incorrect statement intended or likely to mislead or improperly interfere with any elector in or in relation to the casting of his vote. Now, they took that provision and they read it down so that it only applied to misleading a voter about the process of voting, rather than who you might choose to vote for in the election. Moreover, there are practical problems concerning the timeliness of action. Court proceedings take far too long to resolve to be an effective response to misleading advertisements during an election campaign. At most, an interim injunction could be sought, with the matter to be resolved in full proceedings after the election. But this would open up a front of what's sometimes called lawfare, where each side tries to take down its opponent's advertisements and tie up its opponent's finances and attention by having to deal with legal proceedings in the midst of an election campaign. This is why I worry about this headlong gallop towards truth in political advertising legislation, because at best it's just ineffective, but at worst it turns every election into a battlefield of lawyers, politicising the courts and the independent institutions such as the Electoral Commission, while the misleading material not only circulates, but may attain greater free publicity as a result of the complaints and the litigation. Finally, of course, there is, as always, a constitutional point. Political advertising, of course, goes to the very core of the implied freedom of political communication. It's a significant means of communicating with electors and influencing their decisions on how to exercise their vote in elections. Any limit on political advertising is therefore vulnerable to challenge as a possible breach of the constitutionally implied freedom of political communication. So far, the High Court has not resolved the question of whether the implied freedom protects statements that are untrue or misleading. Views have been expressed by judges on both sides of that issue. But assuming for present purposes that the implied freedom does apply, and assuming that the court accepts that it's enacted for the legitimate purpose of preventing electors from being misled in making their choice at elections, the big question will be whether the law is proportionate. This may well turn on how narrowly the law is focused and what defences are available. For example, when the South Australian provision was challenged in Cameron and Becker in 1995, the South Australian Supreme Court noted that Section 113 was restricted to statements of fact, not opinion or comment, that it only applied to electoral advertisements, not speech or other statements, and that it did not penalise those who published inaccurate and misleading statements of fact under an honest and reasonable mistake of fact relying on a common law defence. All these limitations on the offence, which were necessary to support its validity under the Constitution, also had the effect of limiting its effectiveness. The dilemma here is that the more teeth the law has, the more likely it will be to be disproportionate and therefore held to be constitutionally invalid. Personally, I would love all political advertising to be truthful and not to be misleading in any way. And if I could be the political truth fairy and wave my magic wand to make that happen, well, I would. But it seems to me that the type of laws being proposed may be counterproductive and need a much more hard-headed assessment. They are easily avoided and they can be manipulated during electoral campaigns to tie up opponents in litigation. Worse, politicians would no doubt argue that misleading statements have been found to be true if attempts to get them removed fail, even if this is simply because the advertisement contains opinions or predictions which don't fall within the scope of the law. As they tend to say, be careful what you wish for. Thank you for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.